A lot of parents come to me and they say, now my child is 18 and everything is going great and we're not experiencing any barriers to medical issues or financial issues. There are other parents that say, we're having some problems. They might be problems in accessing financial information or healthcare information, and they ask, where do I turn? At that point, obviously it would be to have them start speaking to an attorney. I have a lot of families and they ask, what should I do? Should I just do nothing and let my son or daughter be the self-advocate? Should we talk about healthcare powers of attorney, so I can be involved, or guardianship? As a parent, my answer is whatever it takes to make sure that, in my perspective, that my daughter is safe, that she's not taking advantage of, that she's getting the care that she needs. Those principles usually are what guide families in deciding what it is that they feel might be best. When we're looking at different means of assisting our adults with decision making, it's important to remember that we shouldn't be putting too many things in place when our ultimate goal is to have our son or daughter be able to be as self-determined as possible. Everyone makes mistakes. We learn from them, we grow from them. And it's important for parents to remember that we need to also allow our sons and daughters to make mistakes and learn and grow from them as well. If the individual, when they turn 18 or the age of majority in their state, would like to have parents or other family members assist them with either medical decisions or financial decisions, they could actually go to an attorney and have what are called powers of attorney drafted. A power of attorney is a legal document where someone could give a financial power to someone else to assist them with their financial decision making, or medical power to assist them with their medical decision making. An attorney would need to feel comfortable that the individual who was signing these documents actually understood what it was that they were signing, because they're giving these powers to someone else to assist them. As we know, we're our kids' guardians until they're 18. But at that 18th birthday, guardianship is another option that some families are looking at. They would like to continue being the guardian of their son or their daughter, or perhaps also being a guardian of the assets, and they're two different things. That process is initiated in a court. If I, as a parent, were looking to seek guardianship over my son or daughter or other family member, I would petition the court to become a guardian of the person or the assets. Keep in mind, if you do become the guardian of someone's assets, there are financial accounting and a lot of responsibilities that the court is looking to make sure that you uphold, so the individual with a disability that a guardianship is granted over is not taken advantage of in some financial or other way.
You should check with your state if they have a health surrogacy law. What that means is that oftentimes families get concerned if something were to happen to their child medically and they were not able to make the decision in the moment, who would make that decision for them? A health surrogacy law says that the next of kin can make that decision in an emergency situation. And typically the next of kin order is a spouse followed by a parent. And so if parents are worrying about legal guardianship or power of attorney, it's important to know that if there's a health surrogacy law in your state and an emergency happens, you will be able to make the medical decision for your child in that moment based on your state's health surrogacy law.
Government benefits are sometimes really tricky for people to understand, and they are more complicated because they can be very different for a child who has a disability versus an adult who has a disability. A lot of parents think that everything will kind of continue status quo when our children become adults when it comes to those types of benefits, but that's not exactly the case. To qualify for a needs-based government benefit such as SSI, which is Supplemental Security Income, that's a monthly income from Social Security, and also Medicaid, which is a health insurance program for adults with disabilities, you have to pass certain tests. Not only do you have to have a disability, but you also can't have more than $2,000 in your name of countable resources. A lot of people don't realize that. At that point, families come to me and they are asking a lot of questions. Some of those questions revolve around, well, as a parent, I'm planning on, when I'm no longer here, leaving my estate, if I have a spouse, to my spouse first, and then to be divided between any children I have. If I have a child with a disability, and if in fact they might need government benefits such as SSI or Medicaid, and they can't have more than $2,000, then what do I do? The answer to that question for a lot of families could be to take a look at what's called a special needs trust. A special needs trust is a specialized legal document that assists someone with a disability in protecting any government benefits that they might need now or in the future. The money that goes into a special needs trust is actually protected from being counted as an available resource when it comes to applying for government benefits. Different states call these special needs trusts different things. Some states will call them a supplemental needs trust. Some states call them a special needs trust. It's important to know that if you have one of these documents established and you move to another state, it'd be a great idea to check with an attorney that understands special needs trust law to make sure that it is valid in your state. These trust laws can vary from state to state, and actually benefit programs for people with disabilities can vary from state to state and even county to county. The money in a special needs trust has to be spent solely for the benefit of the person who has a disability, and it cannot replace any government benefits that are out there. So, for example, a special needs trust can pay for all the things that a government benefit is not already providing. I look at government benefits as providing basic needs, food and shelter. The special needs trust is a way to help enhance the life of someone who has a disability. A special needs trust can pay for things that the individual enjoys, the social types of things that cost money to accomplish that perhaps an SSI check or another benefit they're just not providing. Once that happens, when you fund a special needs trust, you would have to set up a separate account, keep an accounting of that, and make sure that the money is spent on the person who has a disability. Parents ask me, what exactly can I put into the special needs trust that I've just set up for my son or my daughter? Well, there are a lot of things that we might leave behind. We might have a home when we're gone that we want to leave to our children. Retirement plans, they could be left to a special needs trust, investments, savings accounts, those types of things. So as you're working with professionals, through the legal side with an attorney, through the financial side through a special needs financial planner, it's important to make sure that you're looking at all the different angles and how this can be done. There's no cookie cutter solution, and if there were, it would be real easy. The great thing is that families can come up with very concise plans. I would strongly encourage parents doing this planning. Please make sure that you are including the person who has a disability at the center of this planning process. The outcome will be so much better. I think it would be a wise decision as families are getting all this information with the person that they're planning for and trying to sort it out, working with someone who is experienced in the legal side of this, a estate planner. They often call themselves elder law attorneys. They're working with Medicaid and benefits and understand special needs planning and special needs trusts. Also working with financial professionals who understand the financial side of this and how to put those things together. While an attorney can draw up trusts, it's important for families to realize once you have these documents, which are basically written instructions on how to deal with your estate when you're gone, that your assets actually talk to them. For example, you go to work every day and they give you some type of benefit, a life insurance policy, a retirement plan. You have to name beneficiaries to those things. If the beneficiary is still listed as your son or your daughter, yet you have a trust that says you want things to go to a special needs trust, they're not talking to one another. Beneficiary designation on a life insurance policy, a retirement plan, they override what your will or your trust would say. So much of financial planning is confidential. No one wants to talk about their assets or their estate. This type of planning is something that parents should be sharing with everyone. If you have a power of attorney or you have a guardianship, other people should know that. Especially if you have a special needs trust, it's important for other family members to know. This type of planning is very different in that we tell people about it. We tell them we have a special needs trust. I'm not asking how much you have. I'm not asking if you're going to leave anything to my daughter. But I'm saying that if you, as a parent, have this document, let people know. Because if their plan is that they would like to include your son or daughter in their estate, this is the way that they should look at doing it. I strongly suggest that parents take a look at creating what's called a letter of intent. A letter of intent is not a legal document. The letter of intent is a document that describes the entire day, from in the morning, do you wake up with the radio or the buzzer on the alarm clock, to what is the process of getting ready to get out of the house for that individual when they're going to work or going to school or doing something else during the day. The medical issues that are in place, how do you help someone with certain medical issues during the day, giving medication. But it's also a lot of the quality of life stuff. This is what we enjoy doing as a family, and we want to make sure that our son or daughter is still included in those things if we're not here to help facilitate those. The letter of intent describes the waiting list that we're on. It describes maybe some of the medical things that we're looking at in the future. If I'm not here to tell someone to be reminded of this, a letter of intent is a great way to do that. The letter of intent should be shared not only with the person that said, yes, I will be there to be the next advocate in line, but share it with other people. Don't hide it away. If I'm no longer here, someone needs to know where my letter of intent is. I need to review it with that person. We talk in acronyms, OT, PT, speech, all these different things. We need to make sure as we have our letter of intent created and we're sharing it with other advocates, they actually understand what it is that we're trying to communicate to them. This is a document that should be created with the person that it's intended to help, and should be updated whenever things change. In all of these plans, keeping the person who has a disability at the table, at the head of the table, in decision making and understanding what all the options are, is the best way to go.